The packed federal courtroom in Washington, D.C. fell into stunned silence as Representative Jasmine Crockett approached the podium. The tension in the air was electric, with spectators filling every available seat and reporters frantically taking notes. What began as a routine hearing on election integrity suddenly transformed into the most shocking legal confrontation of the year. CNN, Fox News, and MSNBC all carried the proceedings live, sensing something historic was about to unfold. Former Florida Attorney General Pam Bondi sat at the respondents' table, her usual confident demeanor intact, until everything changed in an instant. Bondi had just finished delivering what many observers considered a devastating argument against new voting protections. Her voice rang with authority as she concluded. There is simply no evidence of systematic disenfranchisement that would justify federal intervention in state election procedures. Then Representative Crockett, the Harvard-educated attorney representing voting rights organizations, stood up. What happened in the next 30 seconds left everyone speechless. As cameras captured the moment, Crockett calmly opened a folder and pulled out a document that Bondi never expected anyone to discover. Bondi's expression transformed from supreme confidence to visible shock as Crockett revealed evidence that contradicted everything Bondi had just argued. Evidence from Bondi's own past cases and statements. The judges leaned forward. The gallery erupted in whispers, and Pam Bondi, for perhaps the first time in her storied legal career, was left completely speechless. Don't forget to like this video and subscribe to our channel for more incredible moments that are transforming American legal history in real time. Hit the notification bell so you never miss these landmark confrontations as they happen. Pam Bondi, 59, had built her reputation as Florida's first female attorney general, serving from 2011 to 2019. Known for her tough stance on crime and her polished television appearances, Bondi had become a prominent conservative legal voice in America. After leaving office, she had worked with the Trump administration and later joined a prestigious law firm specializing in election law. Her appearances on cable news had made her instantly recognizable, with her articulate defense of conservative legal positions earning her a devoted following. The daughter of a mayor and city councilman, Bondi had politics in her blood. Her 18 years as a prosecutor before becoming Attorney General had honed her skills in the courtroom, where she rarely lost a case. Her commanding presence, meticulous preparation, and ability to simplify complex legal concepts for juries had made her a formidable opponent. Legal observers noted that Bondi's greatest strength was her absolute conviction in her positions. She never appeared to doubt herself, even when facing difficult questions. With her signature blonde hair and tailored suits, Bondi commanded attention in any room she entered. Her legal arguments were typically concise, well-researched, and delivered with unwavering confidence. She had rarely lost a high-profile case, and many observers considered her the favorite in this hearing. As counsel for a coalition of states defending their new voting regulations, Bondi represented powerful interests who wanted to maintain state control over election procedures. Across from her sat Representative Jasmine Crockett, 43, serving Texas's 30th congressional district while continuing to take on select voting rights cases. Unlike many in Congress, Crockett brought real-world legal experience to her political role. Before entering politics, she had worked as a public defender and civil rights attorney, representing clients who couldn't afford high-priced lawyers. What made Crockett especially formidable wasn't just her legal knowledge, but her authentic connection to the communities affected by voting restrictions. She had personally helped voters navigate complicated ID requirements and witnessed firsthand how reduced polling locations created barriers in minority neighborhoods. This wasn't abstract legal theory to her. It was about real people trying to exercise their constitutional rights. The stakes in this case could hardly be higher. At issue was whether new voting regulations in several states violated federal protections by disproportionately affecting minority voters. The regulations had reduced early voting days, eliminated drop boxes, imposed stricter ID requirements, and consolidated polling locations, primarily in urban areas with large minority populations. For Bondi and the states she represented, this case was about preserving state authority over elections and preventing what they called federal overreach. They argued these measures were necessary to ensure election integrity, despite little evidence of significant fraud. For Crockett and the voting rights organizations she represented, this was about protecting the fundamental right to vote against what they saw as a sophisticated attempt to suppress minority turnout. The outcome would affect millions of voters in the upcoming elections and potentially shape democracy for generations. The three-judge panel hearing the case included judges appointed by presidents from both parties. Their decision would likely be appealed to the Supreme Court, making this hearing a crucial step in what promised to be a landmark legal battle over the future of American voting rights. The tension in the courtroom had been building all morning. Outside, protesters on both sides held signs and chanted slogans about democracy and election integrity. News cameras lined the courthouse steps, and several major networks were broadcasting live updates. This wasn't just another legal proceeding. It was a flashpoint in America's ongoing struggle over voting rights. The crowd outside had begun gathering before dawn, with voting rights activists arriving first, setting up with bullhorns and handmade signs reading, "Protect our vote," and "Democracy demands access." By 8 a.m., counter-protesters had assembled across the street, carrying their own messages about election integrity and secure the vote. Police had established barriers to keep the groups separated, but reporters moved freely between them, capturing the passion on both sides. Inside, the historic courtroom was an imposing space with high ceilings, dark wood paneling, and the seal of the United States displayed prominently behind the judges. Every seat was filled with attorneys, law clerks, journalists, and representatives from civil rights organizations. Distinguished legal observers who had witnessed countless arguments sat alongside young law students who had camped overnight for a chance to witness this historic case. The atmosphere was charged with anticipation. Judge Martinez, the senior judge on the panel, had opened the session with a reminder of the gravity of the case. "The issues before us today go to the heart of our democratic system," he stated. "We expect arguments to be factual, precise, and respectful of the serious constitutional questions at stake." Bondi had begun her presentation with her characteristic poise. Standing at the podium in a navy blue suit, she methodically outlined the state's position that the new voting regulations were reasonable, non-discriminatory measures to ensure election integrity. "Your Honors," Bondi said, her voice projecting confidence, "the Constitution grants states primary authority over election procedures. The regulations at issue are content-neutral, apply equally to all voters, and create no undue burden on the right to vote." Judge Wilson, the most skeptical of the panel, pressed Bondi on the evidence. "Ms. Bondi, these regulations appear to have a significantly greater impact on minority communities. How do you reconcile that with the Equal Protection Clause?" Bondi was prepared for this question. "Your Honor, any disparate impact is incidental, not intentional. The states have legitimate interests in secure elections that justify these modest regulations." She then presented statistics suggesting that voter participation hadn't decreased significantly in states with similar regulations. "The plaintiff's claims of voter suppression are simply not supported by the data," she argued confidently. Judge Martinez followed up. "What about the reduction of polling places in predominantly minority neighborhoods? That seems targeted rather than incidental." "Those decisions were based on resource allocation and efficiency, Your Honor," Bondi responded smoothly. "Population density, usage patterns, and available facilities, not race, determined those changes." Then Bondi made a bold claim that would later prove fateful. "There is no evidence in the record that anyone involved in crafting these regulations considered race or partisan advantage. These were good faith efforts to improve election administration." When it was the plaintiffs' turn, their lead counsel presented evidence of long lines in minority precincts, voters who couldn't meet the new ID requirements, and statistical analyses showing the disproportionate impact on Black and Latino voters. Throughout this testimony, Bondi maintained a skeptical expression, occasionally writing notes and whispering to her co-counsel. She appeared confident that the judges would find these impacts insufficient to justify federal intervention. Then Judge Wilson announced, "We'll now hear from Representative Crockett, who is serving as special counsel for the plaintiffs." Crockett approached the podium with measured steps, unlike Bondi's polished television persona. Crockett had the grounded presence of someone who had spent years in courtrooms fighting for real clients. Her dark gray suit was professional but not flashy, and she carried a well-worn leather folder filled with documents. "Your Honors," she began, her voice clear and direct. "I want to address Ms. Bondi's claims about the motivations behind these regulations." Crockett first methodically dismantled Bondi's statistical arguments, showing how the data actually revealed significant decreases in minority participation when properly analyzed. When we control for demographic factors and examine precinct-level data rather than statewide averages, the discriminatory impact becomes clear, she explained. Bondi shifted uncomfortably, but maintained her composed expression. She had faced tough opponents before and wasn't easily rattled, but then Crockett changed tactics in a way no one anticipated. "Your Honors," Ms. Bondi stated, "there is no evidence that anyone involved in crafting these regulations considered race or partisan advantage," Crockett said. "I'd like to direct the court's attention to evidence that directly contradicts this claim." She produced emails and meeting minutes from state election officials explicitly discussing how the new regulations would affect turnout in heavily Democratic urban areas and references to balancing the impact of minority votes. Several of these documents had only recently been obtained through Freedom of Information Act requests. Bondi's expression tightened slightly. These documents were damaging, but not necessarily fatal to her case. She scribbled notes, presumably preparing her rebuttal about context and alternative interpretations. Judge Martinez turned to Bondi. "Counselor, would you like to respond to this evidence?" Bondi rose confidently. "Your Honor, cherry-picked statements from mid-level officials don't reflect the legislature's intent in passing these laws. Policy discussions naturally consider various impacts, but that doesn't prove discriminatory intent. This was standard legal damage control, and Bondi delivered it well." But Crockett wasn't finished. "Ms. Bondi speaks of legislative intent," Crockett continued. "But I'd like to address a more fundamental issue of consistency and good faith." She paused, opening her folder again. The courtroom fell silent as she removed another document. "Your Honors, in 2012, then Florida Attorney General Pam Bondi filed an amicus brief in Shelby County versus Holder. In that brief, she argued that Section 5 of the Voting Rights Act was no longer necessary because, and I quote directly from her brief, "States have demonstrated their commitment to fair election procedures that provide equal opportunity for all citizens to participate." Bondi maintained her professional demeanor, though a slight flush appeared on her cheeks. She had indeed filed that brief, arguing against federal oversight of state election procedures. Ms. Bondi further wrote, Crockett continued, "States should be presumed to act in good faith in election administration, absent concrete evidence of discriminatory intent." Crockett looked directly at Bondi. "I agree with Attorney General." Bondi's standard from 2012, when there is concrete evidence of discriminatory intent, a federal intervention is appropriate. The documents I've just presented provide exactly that concrete evidence. Whispers rippled through the courtroom. Crockett had cleverly used Bondi's own words to establish the standard by which the current regulations should be judged. But Crockett's most powerful move was still to come. She pulled out a third document from her folder. "Your Honors, in 2016, Attorney General Bondi gave a speech to the Federalist Society about election integrity. In that speech, which I have here, she said something remarkable." Crockett held up the transcript. She stated, "When election officials target specific communities with reduced services or higher barriers to voting, that isn't just bad policy. It undermines the constitutional foundations of our republic." A collective intake of breath could be heard in the courtroom. Bondi's expression finally broke from its confident mask into momentary shock. She clearly hadn't expected anyone to unearth this speech from years ago. "Ms. Bondi continued in that speech," Crockett said, her voice steady. "If we found evidence that officials were deliberately making it harder for certain communities to vote, I would be the first to take legal action, regardless of which party was responsible." Crockett placed the speech transcript on the podium and looked directly at the judges. "Your Honors, I couldn't agree more with Ms. Bondi's powerful words. The evidence before you today is precisely the kind of evidence that the former Attorney General herself said would justify legal action. Bondi was visibly unsettled now. The confidence that had radiated from her all morning was cracking. She whispered urgently to her co-counsel, who looked equally concerned. Judge Wilson leaned forward. "Ms. Bondi, would you like to address Representative Crockett's characterization of your previous statements?" Bondi stood, smoothing her jacket as she gathered her composure. "Your Honor, my personal views expressed in a speech to a legal society should not be conflated with the legal standards applicable in this case." The context was entirely different. Crockett interjected, "Your Honors, if I may, principles either apply consistently or they don't." Ms. Bondi articulated the correct constitutional standard in her speech. Targeting specific communities with higher barriers to voting undermines our constitutional foundations. That standard should apply regardless of which communities are being targeted. The gallery erupted in whispers. Law clerks exchanged glances. Journalists scribbled furiously in their notebooks. Everyone in that courtroom recognized they were witnessing a masterful legal trap. Bondi was being held to her own previously stated principles. Judge Martinez called for order. "We'll take a 15-minute recess," he announced. "Ms. Bondi, we'll hear your full response when we return." As the judges filed out, Bondi remained at the counsel table, frantically reviewing documents with her team. For the first time that day, her legendary confidence had been visibly shaken, and Crockett's most powerful evidence was still to come. When court resumed after the recess, the atmosphere had transformed. What began as a routine hearing had become a high-stakes confrontation between two formidable legal minds. Journalists who had been checking their phones were now fully alert. Law students in the gallery leaned forward, notebooks ready. This was the kind of legal drama that would be analyzed in law schools for years to come. Pam Bondi had used the break to regroup. She returned to the courtroom with fresh notes and a determined expression. Known for her ability to recover from setbacks, she was prepared to defend her position and reconcile her past statements with her current arguments. Her legal career had been built on poise under pressure, and she wouldn't be easily defeated. Judge Martinez reopened the proceedings. "Ms. Bondi, you may respond to the arguments presented before our recess." Bondi approached the podium with renewed confidence. "Thank you, Your Honor. I want to address Representative Crockett's references to my previous statements. First," Bondi began, "my 2012 brief in Shelby County argued against the continued need for Section 5 pre-clearance requirements, not against all federal protection of voting rights. The standard I advocated was that federal intervention requires evidence of actual discrimination, not merely the potential for it," she continued smoothly. "As for my speech to the Federalist Society, I stand by those principles. Deliberately targeting communities to suppress votes would indeed be unconstitutional. However, the regulations before this court today are not targeting specific communities. They are neutral measures to ensure election integrity." It was a strong recovery, exactly what one would expect from an experienced attorney like Bondi. She was attempting to create distance between her past principles and their application to the current case. But Jasmine Crockett was ready. As Bondi returned to her seat, Crockett asked, "Your Honors, may I respond?" Judge Wilson nodded. "Briefly, Representative Crockett." Crockett approached the podium again, carrying what appeared to be an even thicker folder than before. She placed it down with a soft but audible thud that drew every eye in the courtroom. "Ms. Bondi has correctly stated that her principle was that federal intervention requires evidence of actual discrimination," Crockett began. "I agree completely with that standard. The question is whether we have such evidence in this case." Crockett opened the folder and removed a stack of documents. "Your Honors, I have here something that wasn't available during the initial discovery phase of this case." She held up several pages of what appeared to be emails and meeting minutes. "These documents were obtained last week through a separate Freedom of Information Act request related to another matter." Bondi straightened in her chair, a flicker of concern crossing her face. "These are internal communications from the Secretary of State's Election Procedures Committee in 3 of the states Ms. Bondi represents," Crockett explained. "They include frank discussions about the expected impact of these new regulations. Crockett handed copies to the court clerk for distribution to the judges. I'd like to direct your attention to the highlighted sections on pages 3, 7, and 12. As the judges reviewed the documents, Crockett continued. On page 3, the committee chair writes, and I quote, "The new ID requirements should help offset the demographic challenges we face in Atlanta, Detroit, and Milwaukee." On page 7, another official notes, "Consolidating polling locations in urban districts will have the added benefit of reducing turnout in areas that traditionally vote 80-20 against us." The courtroom was completely silent now. These statements directly contradicted Bondi's claim that race and partisan advantage weren't considered. Most significantly, Crockett said, turning to page 12, "There's an email from a senior election official stating, 'The beauty of these measures is they're facially neutral, but will help solve our minority turnout problem.'" Judge Martinez looked up sharply. "Ms. Bondi, were you aware of these communications?" Bondi rose, her composure still intact but clearly strained. "Your Honor, I've not seen these specific documents before." Without context, isolated statements can be misleading. These appear to be from individuals, not official policy positions. "That's a fair point," Crockett acknowledged. "Which is why I'd like to submit one final piece of evidence. From her folder, she produced a document that appeared to be a memorandum on official letterhead. "This is a strategy memo," Crockett explained, "prepared for a closed-door session with election officials from these states. It outlines the expected outcomes of the new regulations." She began reading from the document. "While publicly we must maintain these measures are about election integrity, internally we should acknowledge they will create a turnout differential of approximately 3 to 5% in favor of our constituencies. This is achieved primarily through higher impact on low-income and minority voters who typically vote Democratic." The memo continued. "The measures most likely to achieve this differential include reduced early voting in urban areas, strict ID requirements, and polling place consolidation in targeted districts." Crockett paused to let this sink in. "Your Honors, this memo doesn't just suggest discriminatory intent, it explicitly states it." She turned to face Bondi directly. "By Ms. Bondi's own standard, the standard she articulated in both her Shelby County brief and her Federalist Society speech, this evidence of deliberately making it harder for certain communities to vote should trigger federal intervention." The courtroom remained silent as Crockett delivered her most devastating point yet. "Ms. Bondi said she would be the first to take legal action if such evidence emerged. Well, here is that evidence. The only question is whether she will stand by her principles when they lead to an outcome that may not align with her current client's interests." Bondi's normally unflappable demeanor had completely faltered. She appeared genuinely shocked by the memo, suggesting she might not have been aware of its existence. This placed her in an impossible position: either acknowledge the validity of the evidence and undermine her client's case, or attempt to defend actions that violated the very principles she had previously championed. Judge Martinez turned to Bondi. "Counselor, do you wish to respond to this new evidence?" Bondi rose slowly, visibly processing the implications of the documents. "Your Honor, I would request time to review these documents and verify their authenticity." "That's a reasonable request," Judge Wilson acknowledged. "However, assuming for the moment that they are authentic, how would you reconcile them with your previous arguments about the state's intentions?" It was the question Bondi least wanted to face, and the entire courtroom knew it. After a moment of tense silence, Bondi spoke carefully. "Your Honor, if, and I emphasize if, these documents are authentic, they would certainly require serious examination. As I stated in my Federalist Society speech, targeting specific communities with voting barriers would be improper." It was a significant concession, though couched in cautious language. "So you agree," Judge Martinez pressed, "that evidence of such targeting would justify federal intervention under the standard you yourself advocated?" Bondi was trapped between her past principles and her current case. "Your Honor, consistent application of constitutional principles would indeed require heightened scrutiny in such circumstances." Crockett seized this opening. "Ms. Bondi and I appear to agree on the fundamental standard. The only question is whether the evidence meets that standard. I believe the documents I've presented today clearly do." Judge Martinez turned to Crockett. Representative Crockett, beyond identifying this inconsistency, what specific remedy are you seeking? This was Crockett's opportunity to translate her legal victory into practical protection for voters. She stepped forward with renewed purpose. Your Honors, we ask the court to issue an injunction blocking implementation of these regulations before the upcoming election. Further, we request court-supervised development of new procedures that ensure equal access for all voters, regardless of race, income, or location. She continued with unexpected magnanimity. And I want to acknowledge something important. Election integrity is a legitimate goal. We don't oppose all verification measures. What we oppose are measures designed to create unequal burdens. This nuanced position demonstrated that Crockett wasn't pursuing a partisan agenda, but genuinely seeking fair voting procedures. It made her argument more compelling to the moderate judges on the panel. We would welcome Ms. Bondi's expertise in crafting solutions that both maintain election integrity and ensure equal access, Crockett added, extending an olive branch to her opponent. Her own words from the Federalist Society speech provide an excellent framework for such balanced solutions. This masterful move put Bondi in an even more difficult position. Rejecting this olive branch would make her appear partisan rather than principled. Accepting it would essentially concede defeat in the current case. Judge Martinez sensed the significance of the moment. This seems like an appropriate time to conclude today's arguments. We'll recess while the panel considers these matters. I suggest both parties prepare for the possibility of developing alternative procedures under court supervision. As the judges filed out, the courtroom erupted in hushed conversations. Legal observers exchanged astonished glances. Journalists rushed to file stories about the dramatic confrontation they had just witnessed. Political commentators who had predicted a routine legal proceeding suddenly found themselves scrambling to understand the significance of what had just happened. Within minutes, legal experts from both sides of the political spectrum were being called into TV studios to break down the confrontation. What we just witnessed wasn't just clever legal maneuvering, explained constitutional law professor Lawrence Tribe in a hastily arranged CNN interview. Representative Crockett fundamentally changed the frame of the debate from partisan talking points to consistent legal principles. That's extraordinarily rare in today's polarized environment. Bondi remained at the counsel table, her usual commanding presence diminished. For the first time in her storied legal career, she had been outmaneuvered not by new legal theories, but by her own previously stated principles. Crockett gathered her documents calmly, acknowledging supportive nods from civil rights attorneys in the gallery. She had not only won a crucial legal battle, but had done so by appealing to consistent principles rather than partisan advantage, the very approach Bondi herself had once advocated. As the courtroom began to clear, veteran legal reporters who had covered hundreds of cases like this one found themselves struggling to contain their professional detachment. "I've never seen anything quite like that," whispered one Washington Post journalist to a colleague. She didn't just win the argument, she changed the entire framing of voting rights litigation. Behind the scenes, law clerks for the three judges were already discussing how the arguments would affect their draft opinions. One clerk was overheard saying, "This is why I went to law school, to see advocacy that actually advances legal principles rather than just partisan positions." As they prepared to leave the courtroom, Bondi approached Crockett, a gesture that surprised everyone watching. "Representative Crockett," Bondi said quietly. "That was exceptionally well argued." Crockett nodded respectfully. "Thank you, Ms. Bondi. I meant what I said about welcoming your expertise in crafting balanced solutions. Election integrity and equal access aren't mutually exclusive goals. It was a moment of professional respect amid intense legal and political conflict. A reminder that even in America's most divisive battles, principled advocacy can sometimes transcend partisan divisions." As Bondi walked away, everyone in that courtroom knew they had witnessed something extraordinary. A legal confrontation where principles had trumped power, where consistency had defeated convenience, and where one brilliant advocate had used her opponent's own words to reshape the debate about voting rights in America. The shockwaves from the Crockett-Bondi confrontation reverberated far beyond that Washington, D.C. courtroom. Within hours, video clips of the exchange had been viewed over 15 million times across social media platforms. The hashtag Garden Bondi vs Crockett began trending nationwide, with users debating not just the legal arguments, but the larger implications for how principled consistency should guide legal reasoning, the moment captured public attention in ways that legal proceedings rarely do. Morning shows that typically avoided complex legal issues devoted entire segments to breaking down the confrontation. Podcasters who never touched on voting rights suddenly found themselves explaining Crockett's strategy to their audiences. Even late-night comedians incorporated the courtroom drama into their monologues, with one joking, "Crockett didn't just win a legal argument, she basically created a new debate format. Here's what you said when you actually meant it." Legal analysts on every major network dissected the unprecedented courtroom drama. Constitutional scholars who typically spoke in dry academic terms found themselves explaining the significance to mainstream audiences with unusual clarity and passion. CNN's legal analyst Jeffrey Toobin described it as the most effective use of an opponent's past statements I've seen in 30 years covering the courts. On Fox News, even conservative legal commentators acknowledged the tactical brilliance of Crockett's approach. "Whatever your position on the underlying issue," said former federal prosecutor Andrew McCarthy, "what Representative Crockett did was a master class in appellate advocacy." The New York Times ran a front-page headline, "In stunning courtroom exchange, Crockett uses Bondi's words to reshape voting rights case." The Washington Post followed with, "Principles versus politics. How consistency became the central issue in landmark voting rights case." Law schools immediately began requesting transcripts of the arguments for inclusion in their advocacy courses. This is the perfect case study in how to respectfully but effectively hold opposing counsel to their own stated principles, explained Professor Melissa Murray at NYU Law School. Crockett didn't attack Bondi personally. She elevated Bondi's earlier principled statements and asked for their consistent application. Social media erupted with reactions from legal experts, politicians, and ordinary citizens. Bondi principles and Crockett consistency trended nationally for days. Many observers noted the historical significance of a black woman effectively using the words of a prominent, conservative legal figure to expand voting protections for minority communities. 3 days after the hearing, the three-judge panel issued its ruling. In a surprising 3-0 decision, they granted the injunction blocking implementation of the new voting regulations. Judge Martinez's opinion directly referenced Bondi's past statements. "When evaluating evidence of discriminatory intent, we find the standard articulated by counsel in her previous writings persuasive. By that standard, the evidence presented clearly justifies federal intervention." Most significantly, the court ordered the creation of a bipartisan commission to develop new procedures that would both protect election integrity and ensure equal access for all voters. In an unexpected move, the judges suggested that both Crockett and Bondi be included as advisors to this commission, a testament to how their courtroom confrontation had elevated principles over partisan positions. For Bondi, the aftermath presented both challenges and opportunities. Initially, some partisan commentators criticized her for failing to defend the regulations more aggressively. But as legal analysts highlighted her impossible position, trapped between her past principles and her current case, public perception began to shift. In a move that surprised many, Bondi gave an interview to the Wall Street Journal a week after the ruling. "While I disagree with aspects of the court's decision," she said, "I stand by my belief that voting procedures should be both secure and equally accessible to all citizens. Those principles aren't partisan, they're constitutional." This principled response earned Bondi respect across the political spectrum. Rather than appearing defeated, she emerged as someone unwilling to abandon core legal principles for partisan advantage, a reputation that would ultimately enhance her standing in legal circles. For Crockett, the aftermath transformed her from a respected but relatively unknown congresswoman to a national figure in legal and political circles. Law firms and advocacy organizations flooded her office with requests to lead major constitutional cases. Her office reported receiving over 10,000 messages in the first week, from constituents, law students, and even several state court judges expressing admiration for her approach. "I don't share Representative Crockett's political views," wrote one conservative judge from Georgia. But her argument was a magnificent demonstration of how legal principles should transcend political preferences. She has earned my deepest professional respect. The practical implications of the ruling were immediate and far-reaching. States across the country with similar pending legislation quietly withdrew or modified their bills rather than face certain legal challenges under the newly clarified standard. Voting rights organizations began systematically reviewing existing regulations that might be vulnerable under what was now being called the Bondi-Crockett framework for evaluating discriminatory intent. 2 weeks after the ruling, something extraordinary happened. The bipartisan commission held its first meeting, and both Crockett and Bondi attended as advisors. Observers expected tension, but instead witnessed something remarkable. Two brilliant legal minds finding unexpected common ground. "We both agree," Crockett said during a joint press conference after the meeting, "that election procedures should be secure, efficient, and equally accessible to all voters. The question isn't whether to verify voters' identities, but how to do so without placing undue burdens on certain communities." Bondi nodded in agreement. "There are solutions that serve both interests," she acknowledged. Mobile ID services that reach underserved communities, expanded early voting that accommodates various work schedules, and sufficient resources to prevent long lines in all neighborhoods. This surprising collaboration became a template for addressing voting rights issues in several states. Rather than endless litigation, some jurisdictions began adopting the Bondi-Crockett principles, procedural changes that maintained security while removing discriminatory barriers. 6 months later, the impact on voter participation became clear. In states that had implemented these balanced approaches, turnout increased across all demographics. Most significantly, disparities in wait times between urban and suburban precincts decreased dramatically. Crockett's office released a statement. "These results confirm what we argued in court. Protecting election integrity and ensuring equal access are compatible goals. When procedures are designed with both principles in mind, democracy thrives." Legal scholars noted that the case represented a potential turning point in voting rights jurisprudence. Harvard Law Review published a special issue titled "Principle-Centered Advocacy: The Crockett Approach to Constitutional Litigation," featuring articles from legal scholars across the ideological spectrum. The impact extended to law schools nationwide, where the Crockett-Bondi exchange became required viewing in advocacy courses. "What made Crockett's approach so effective," explained Yale law professor Heather Gerken, "was her focus on shared principles rather than partisan division. She found the common ground that even her opponent had previously acknowledged. Perhaps most significantly, the case changed how many Americans viewed voting rights issues. By framing the debate around consistent principles rather than partisan advantage, Crockett had created space for consensus that transcended the usual political divides. A year later, when Congress considered new federal voting rights legislation, both Crockett and Bondi testified before the Senate Judiciary Committee. Though they disagreed on specific provisions, their emphasis on principle-centered solutions influenced the final bill, which included both security measures and accessibility protections. At the conclusion of her testimony, Crockett was asked about the lasting impact of her courtroom confrontation with Bondi. "That moment wasn't about winning a legal argument," she reflected. "It was about reminding us that constitutional principles should apply consistently, regardless of who benefits politically. When we anchor our legal system in consistent principles rather than convenient outcomes, we strengthen democracy itself." In law schools, advocacy organizations, and courtrooms across America, the Crockett-Bondi confrontation became more than a dramatic legal moment. It became a model for how principled advocacy could bridge America's deepest divisions. And it all began with one brilliant advocate who believed that consistency mattered more than convenience, that principles should transcend politics, and that even her opponent's words contained wisdom worth preserving. Don't forget to like this video and subscribe to our channel for more incredible moments that are transforming American legal history.
Hit the notification bell to never miss updates on how the Bondi-Crockett principles continue to reshape voting rights across America.
Leave a comment below sharing your thoughts on this historic legal confrontation.